I'm posting this video because I've seen a lot of posts about SB 1588, a lot about fences, a lot about security measures, a lot of misinformation. So I'm posting this video to clarify and educate. Remember, this is not legal advice. This is only for educational and informational purposes only. So SB 1588 was passed last year. Some of these code sections became effective immediately. Some of them became effective as of November, some a little bit later. But this particular security measure statute became effective partly immediately and partly September 1st of last year. So this has been effective for some time now. This code section does not apply to condominium associations. It only applies to residential associations. It also doesn't apply to mixed master use associations. So those are defined in other code sections. And this code section is under Chapter 202, and it is section number 202.023. And this is not just in regards to fences, it's in regards to all security measures. So it doesn't define exactly what that means. It gives so there's some limiting language in this statute, and there's some allowances for associations to restrict in this statute. Now, lawyers don't write the law. I get this question too all the time. Why couldn't you write it in a particular way? Well, I didn't write it. The state legislature writes the statute. I know that some legislators, some senators and representatives talk to lawyers about how the statute should be written. And so sometimes it's written in a very broad way. Sometimes it's written in a very narrow way, depending on if the legislator can get support for that statute. So I'm going to actually post a video on that because I get a lot of questions about that all the time, about how a statute's written, why it's written in a particular way. Do we have, as lawyers, have any input about how it's written, and about committee hearings and how to participate in committee hearings and how to participate in talking with your state legislators on HOA rules. So that's like a whole nother topic that I can talk about. I could probably talk about it forever. But for this particular statute, they have stated that a property owners association cannot adopt or enforce a restrictive covenant or a deed restriction that prevents a property owner from implementing security measures. And they have given a list, but not an exhaustive list. So the statute states that security measures are including but not limited to. So it's including these things in the statute, but it's not limited to just those things. So what does that actually mean for us as lawyers when we're trying to determine what a security measure is and what is not a security measure? I think it's kind of difficult, and we're going to have to wait for case law to be able to make those arguments for the association, especially if you're a lawyer who represents associations. I think it's really hard for us to determine how to deal with some of the conflicts that come with that. So they have included security cameras, motion detectors, or perimeter fence. And that is where most of the issues come along. Well, most of what I've been getting questions on. So what is a perimeter fence? Is a perimeter fence just in regards to the backyard, or can it be the entire lot? And what it seems to infer, the statute, is that there is no limiting area in which you can put a fence in. So it seems like the statute's allowing for a perimeter fence around the entire lot. I think this is going to create a lot of issues. And again, we're going to have to wait for case law to, determine whether the court will allow limiting a perimeter fence just to the backyard. But it seems to, we'd have to look at legislative intent and whether the legislature anticipated those arguments. So it's going to have to be, most likely going to have to be litigated in court, and it'll have to be appealed, because we can't, there are no decisions at the trial court level that will determine the actual rule. So this is why some of these statutes create a lot of issues with associations, is because when they're enacted, we as lawyers then have to make those particular arguments in court, and it's an expensive endeavor for an association to do that. So that's why we don't see a lot of appeal court decisions in regards to HOA rules, because it's the homeowner then has to pay for the trial, and they also have to pay for the appeal, and so same thing with the association. And this statute allows the association to limit the type of fencing. So if the association wants the fencing to be just wrought iron, or if they want it to be just boards, or they want it to be crisscross, or they want it just, the type of wood being used, or type of materials, and how high the fence is, I think that the association can still be able to regulate that. Same thing with the security camera. There is case law in regards to security cameras being pointed at neighbors' backyards. So there is some case law in regards to that. So this is definitely a problematic situation for associations, but we'll just have to let the case law run through the courts to determine exactly what the legislature actually meant by this particular code section. Thank you for watching. I know it didn't give a lot of information, but it is a code section that comes up a lot, and I think it's important to start talking about this stuff, especially for management companies and for associations, so that we can all learn from each other and move forward in the most effective and efficient and fair way.